With Thursday, thank you, March 6th. The week is long, but it is Thursday, so that's good. We're going to start off with a hearing on Senate Bill 222, and then we have a list of bills that I really hope we can get through and work. I want to welcome Representative Neighbor here, who's filling in for Representative Martinez. Thanks for being here. And I think we'll go ahead and get started with the hearing. I'll open that. Senate Bill 222 and ask Jason Thompson, the reviser, to give us a bill brief.
All right. Thank you, Madam Chair. Good afternoon, committee. As you mentioned, Jason Thompson, Revisor's Office. Senate Bill 222 comes to you as amended by the Senate committee. It prohibits deference to a state agency's interpretation of a statute, rule, or regulation or document by a state court or an officer hearing an administrative action. The bill is a new section of law. It states that in interpreting a state statute, rule, and regulation or document that has the force and effect of law, a state court or an administrative hearing officer hearing an administrative action may consider but shall not defer to a state agency's interpretation of such statute, rule, and regulation or document, and shall interpret the meaning and effect of such statute, rule, and regulation or document de novo, which is the Latin for anew or, fresh, that sort of thing. So an action brought by or against the state agency after applying all customary tools of interpretation and rules of statutory construction, a state court or administrative hearing officer hearing the action shall exercise any remaining doubt in a way that is consistent with an individual's fundamental constitutional rights. So that is what the new section would provide. I note that it does incorporate two definitions from the Kansas Judicial Review Act. Those are referenced there for rule and regulation and state agency. And the last thing I usually note is that it passed the Senate, and I did not bring my sheet up with me that says what the vote was. So I'll have to get that for you from my research counterparts that are sitting at their computers. I'll have that for you in just a moment. All right. Thank you, Representative and Madam Chair. 31-9 for everyone who's not able to hear off mic. All right.
Okay, committee, do you have any questions for the reviser on Senate Bill 222? Representative Schreiber.
Thank you, Madam Chair, and thank you, Jason. Is there a definition for fundamental constitutional rights anywhere? I mean, elsewhere in the statute or anything, or is that just a term of art, so to speak?
Madam Chair, Representative, I mean, there are certain rights that have case law calling them fundamental, so I don't know that I go as far as calling it a term of art, which has a little bit more meaning to the lawyers in the room. But I think it is a legal concept that has some meaning, but there's not a specific definition. There are certain rights that have been deemed fundamental constitutional rights in the case law, and that's probably what the definition would be closest to, yeah.
Okay, thank you, Madam Chair.
That is a great question. I remember asking a law school professor that. There wasn't a great answer. Well, it just depends. It's the perfect answer for every attorney. It depends. Okay, Representative Carmichael.
Thank you, Madam Chair. And to follow up on Representative Schreiber's question, the law already is it not, that fundamental constitutional rights trump statutes or other interpretations of the contrary? Isn't the Constitution the supreme law of the state and of the land?
Madam Chair, yes, generally speaking, that's accurate. You can find statutes, for example, unconstitutional because they are a violation of a fundamental constitutional right. So yes, those are competing interests at times, yes.
Thank you, Mr. Thompson. Thank you, Madam Chair.
Do we have any other questions, committee, for the reviser? Okay, Jason, I just want to, for those that are sorry, and you didn't quite get away. For those new members on the Judiciary Committee, the bold, italicized are the amendments that the Senate made. Could you just explain that one
Sure.
more time? Thank you.
Yes, so Madam Chair, talking about fonts again, this is a common occurrence when we start amending bills. So as you see at the top of the bill, in bold italic is the words "as amended by Senate committee." And then the amendments made by the Senate committee are in that same font, bold italic. In this case, it's a new statute, so the amendments they made were, on page 9, or on line 9, 15, and then that strike in lines 16 through 18, they also made that. And then they made the addition in its place in line 18 and 19, so.
Yeah, thank you for that explanation. Okay, thank you. All right, I will now call our one in-person proponent, Jim Manley from Pacific Legal Foundation. Welcome to our House Judiciary Committee.
Thank you, Madam Chair, members of the committee. My name is Jim Manley. I'm the State Policy Chief for Pacific Legal Foundation. PLF is a national nonprofit law firm. It was founded 50 years ago by members of Governor Reagan's cabinet. And since then, we've been litigating in defense of property rights, separation of powers, and equality and opportunity. Our concern with this bill, our support for this bill comes from our work in separation of powers. The separation of powers is the surest protection we have for individual rights. I litigated constitutional cases for 15 years. The Bill of Rights is a wonderful protection for individual rights, but the most fundamental protection we have is the separation of powers into each separate branch of government. And the administrative state threatens to combine all three branches of government into one body. And so when an agency brings an individual into court or before their own administrative hearing, it's fundamentally important that the court not put a thumb on the scale in favor of the agency's interpretation of the statute that the agency is charged with enforcing. And in fact, Kansas courts have recognized this for a decade. Kansas courts do not apply deference to agency decision-making. So what this bill does is simply codify the good practice of Kansas courts over the last decade and ensures that that good standard remains the law regardless of how the court might change in the future. The second part of the bill that requires decision makers to defer if there's an equal question about whether the statute before them gives the agency the power to do something, to, in that case, defer to the Constitution and fundamental rights protected by the Constitution. And that's also existing Kansas law. We often think about this as the rule of lenity in the criminal context, where if the rule of the statute, the prohibition, is not clear, then the tie goes to the individual rather than the government. And that is fundamentally what the second part of this bill does. With that, I urge your support, and I'm happy to stand for questions at the appropriate time.
Okay, thank you. Committee, what questions do you have for Mr. Manley? Representative Vaughn.
Thank you, Madam Chair, and I apologize for being late, so I apologize if any of these questions got asked of the revisor. And thank you, Mr. Manley, for your testimony. I did have just two questions. I'm wondering, in the bill, I'm trying to figure out the reason for the inclusion of document or an example of a document that this law would be applicable to. Statute, rule, regulation, that makes sense to me, but the document was something that I was unfamiliar with.
Madam Chair, Representative Vaughn, agencies can produce guidance documents that inform the public about how they interpret their statutes or their regulations. And courts in other states or at the federal level will often defer to the agency's interpretation of those documents and the interpretation of the statute and rules that are contained in those documents. So that is what documents would refer to there.
Thank you for that clarification. I was reading through the neutral testimony, and there was concern that that could potentially be applied to, let's see. Sorry. It was not a guidance document, but I think in regards to I'm sorry, I'm not seeing it here. I'll come back to that, but I appreciate that clarification on that. My second question was just the difference between in section 1 of the bill, in subsection A, it says that the force and effective law state court or an administrative hearing officer hearing an administrative action may consider but shall not defer to a state agency's interpretation of such statute, rule, regulation, or document, and shall interpret the meaning de novo. In my mind, it's a little bit redundant. So what's the point or what's the thought process behind saying shall not defer and also de novo? Because I'm wondering if there's other legal precedent, if there are other types of precedent that could be applicable in the case. De novo would prevent the administrative hearing officer to consider that precedent as well.
Madam Chair, Representative Vaughn, there's two situations that covers that are slightly different. So deference would refer to the agency's interpretation of the statute or regulation, right? So the agency says that the statute or regulation means this, and a court applying deference would adopt that interpretation. De novo would refer to a situation where, say, an administrative agency has made an interpretation of a statute or regulation, and then that interpretation is being appealed to a court. So a slightly different situation, but similar. But there's a difference there, which I hope I've explained clearly.
So just to clarify, so the de novo would be a situation in which an agency regulation was appealed and then that resulted in a legal decision?
Madam Chair, Representative Vaughn, yes, I think that is I'm not sure if there'd be other situations where that would apply, but that is the primary situation where de novo review would be relevant.
Okay, that's helpful. Thank you.
Okay, committee, who else has questions? Representative Carmichael.
Thank you, Madam Chair. I will attempt to be appropriately brief in view of the amount of work we have ahead today. Is it Mr. Manley? Is that correct, sir? It looks to me like this bill does two things. One, it deals with the doctrine of operative construction, and two, it says that fundamental rights are fundamental rights. Do you agree with what our reviser told us a few moments ago, that the Constitution is already the supreme law of the state and that it trumps, if you will, statutory enactments?
Madam Chair, Representative Carmichael, I do agree with that. I would just elaborate to say that I think it's important to codify both of those concepts in statute because they are ultimately, currently, dependent on the interpretation of the courts. And so I think in my view, it's important for the legislature to take a position on those issues and take a position on how courts should interpret statutes and regulations and how courts should interpret those statutes and regulations when fundamental constitutional rights are implicated, even though the courts have arrived at the right question on both of those issues in Kansas. That's no guarantee of that happening in the future.
And so then we're in agreement when it comes to the substantive matter before us here of the doctrine of operative construction, that in fact the law of Kansas is very clearly stated in the Douglas versus Ad Astra case, which you cite in your testimony, where, as I recall, it was Justice Johnson, who still serves on the court, who said, to quote, "To be crystal clear, we unequivocally declare here that the doctrine of operative construction, as described in the Court of Appeals opinion, has been abandoned, abrogated, disallowed, disapproved, ousted, overruled, and permanently relegated to the history books where it will never affect the outcome of an appeal." Now, that's about as strong language as I've ever heard an appellate court use. So what are we changing here other than the law as it already exists?
Madam Chair, Representative Carmichael, I will disagree with one word in that quote, which is permanent. There's nothing permanent about a court decision, as we've seen in recent times at the Supreme Court level. In fact, the issue of deference that we're talking about today, the Supreme Court just recently overturned deference on the federal level, which had been the law of the land for 30 some odd years.
That's Chevron, the Chevron doctrine.
Exactly, yep. And so courts change and case law can change. And so that, I think, is the whole reason that we're here today.
Madam Chair, if I might beg your leave for one more question, which will give me
Go ahead.
three. But if you're concerned about courts in the future changing the law by judicial opinion, decision, etc., what's defined as fundamental rights? That has changed in many ways over the years. I mean, at one time in this country, for example, women didn't have a right to vote. People of color didn't share the same rights. So why would this give you any more assurance? I mean, this entire doctrine of what's a fundamental right is something that's argued about today. Why don't we just leave the law as it is? And if something goes wrong, then we'll deal with the specific error that you might contend a court made.
Well, Madam Chair, Representative Carmichael, I think there's what the saying is, an ounce of prevention is worth a pound of cure. And I think perhaps and the bill originally was, I think, a little bit broader or in that second part. And so it narrowed a little bit to simply refer to fundamental constitutional rights. But I think it still enhances protections for Kansans and gives greater assurance that the law on deference and fundamental rights will remain as it has been going into the future. And again, I think this is a question where it's important for the legislature to take a position on this issue, and the courts have taken a position on deference, and I think it's important for the legislature to also state its view of how the statutes that it enacts should be interpreted.
I appreciate your careful answers, Counsel, and Madam Chair, I just might observe that some might call an ounce of prevention is worth a pound of cure. Others might describe that as jousting at windmills, and that's my opinion of this legislation. Thank you.
Committee, do you have any other questions? Representative Lewis.
Yes, thank you, Mr. Manley. So, on the one hand, if I were a court, these are the rules of construction that I would apply. On the other hand, going back to Marbury versus Madison, the court there said that courts are the ultimate determiner of what the law means. And I would think that if I were on the court, I might bristle at the legislature telling me how to do my job. So my question is, are you aware of any statutes similar to this that have been passed in other states and how they have been received by the courts?
Madam Chair, Representative Lewis, there are 6 states that have enacted, that have prohibited deference legislatively, 1 state that did it by ballot measure, and 7 other states, including Kansas, where the courts have relegated deference to the dustbin. I'm not aware of any judicial uprisings in any of those 7 states where it was done through the political process. And I'll add as well, the section of statute that this would fit into already gives the court guidance about how to interpret statutes. So this is not a new feature of Kansas law. I don't have that citation off the top of my head. I'm sorry, but I can look that up and get it to you. But there is a section of Kansas statute already that provides guidance to courts about how to interpret statutes.
But you're not aware of any court in Kansas or in another state actually taking up this issue as to whether or not such guidance or even direction on how to go about interpreting statutes, whether that violates the checks and balances, the separation of the authority of the various branches?
Madam Chairman, Madam Chair, Representative Lewis, I can't think of an example off the top of my head. No, I'm sorry.
Okay, committee, any other questions for Mr. Manley? Okay, thank you so much. We appreciate you being here.
My pleasure. Thank you.
Committee, also, we have written-only proponents from Randy Stuckey from Kansas Grain and Feed, Eric Stafford from the Kansas Chamber, Elizabeth Patton from Americans for Prosperity Kansas, and Brian Norman from the Goldwater Institute. No opponent testimony that we got, and neutral written-only from Dorinda Mitchell from the Kansas State Board of Healing Arts. So please take a look at that as you are considering the bill. And I will close the hearing on Senate Bill 222. Thank you. Okay, committee, we are going to work some bills now. And we're going to start with Senate Bill 135. So if you have use paper, you might want to pull out some of your folders. And if you use the S drive, we're going to start with Senate Bill 135. And we will have Jason give us a reminder about what Senate Bill 135 is about. Okay, it's on March 4th on the S drive, if that's helpful. Yes, of course you are.
All right. Thank you, Madam Chair.
Okay, Jason will now give us a reminder of Senate Bill 135.
All right, thank you again. Senate Bill 135 is the bill that provides precedents of certain child-related orders issued under the Protection from Abuse Act. This is the bill from the Coalition Against Sexual and Domestic Violence and the Judicial Council that you heard about that reorganizes the statute about how orders are given precedence over other orders issued on the same child in different matters. And that's probably good enough.
Okay.
Yeah.
Yep, thank you. Does anyone have any questions about that? Okay. So we're gonna work these bills the same way that we did the last batch, where we talk about them first before we get a motion. So do we have any comments or any amendments on Senate Bill 135? Representative Vaughn.
Thank you, Madam Chair. I have a technical amendment.
Okay, great, thank you. If you would have them pass it out and you can explain it to us.
Thank you, Madam Chair. This is the just the notation technical amendment that was mentioned in testimony where there needed to be a renumbering. So it's just changing subsection C on page 2, line 26 to large parent 1.
Okay, I'll let you guys just take a look at that as it's getting passed out. The smallest amendment ever done.
Dare I say it's a simple amendment?
I don't know. Would you like to move your amendment? Yeah.
Thank you, Madam Chair. I move my amendment.
Do we have a second? Representative Bohai seconds. Any discussion on the amendment? Okay, would you like to close?
I close.
Okay, so you've heard the amendment from Representative Vaughn on Senate Bill 135. All those in favor say aye. Opposed, no. Okay, so we have amended Senate Bill 135.
Madam Chair, would you please record my affirmative votes in the minutes of this?
Really? Okay, yes. Representative Carmichael, like a yes vote on this amendment.
That was the amendment. I was too soon. I was really waiting for the substantive bill. That was the, never mind. I apologize. No need to take up that extra space over a technical amendment. I apologize.
Yeah, that's true. Mike Miller on that number 1.
If it was
Okay.
an Oxford comma, that would be different, Madam Chair.
Totally. That is a substantive issue, as we know. So, okay, committee, any other amendments on this bill or discussion? Okay, do we have a motion on this bill? Representative Williams.
Thank you, Madam Chair. I move that when the body rises and reports, it reports Senate Bill 135 as amended favorably for passage.
Thank you. Seconded by Representative Schreiber. Any other discussion on Senate Bill 135? Okay, you have heard the motion to pass Senate Bill 135 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, we have worked our first bill of the day. Senate Bill 135 is passed favorably. I'm sorry, and Representative Carmichael would like his yes vote in the minutes. Okay, next we're going to do Senate Bill 71. And Jason, go ahead when you're ready.
Thank you, Madam Chair. Senate Bill 71 is the bill about buying sexual relations. It removes all the provisions about city ordinances because this will now be a felony. There won't be city ordinance violations of that crime. It also requires the Attorney General to make a new educational or treatment program regarding commercial sexual exploitation that will be used for offenders convicted of certain crimes going forward.
Okay, committee, any amendments or discussion on Senate Bill 71? Representative Barrett.
Thank you, Madam Chair. I'd just like to say I think this is a really great bill. I mean, I think the data clearly shows that many of the women that are involved in this are being trafficked. And so if we can attack the demand side and hold buyers accountable, I think that's really important for all of us to do. Thank you.
Okay, thank you for that. Committee, I do have an amendment. And we can pass it out. I think you're familiar with this amendment. This amendment, oh no, this is it's a real amendment. Okay. Okay. Yes. Okay. Okay. So you'll get a copy of this, and Jason will explain it.
Thank you, Madam Chair. So normally we're looking for effective date amendments, and we don't love those on criminal bills anyway, but in this particular case, I noticed I made a mistake in drafting the bill, potentially. So this would correct a little bit of an oversight. So on page 8, this is the only change in the balloon. You can see the new language in lines 20 through 23. The attempt here is to make clear that a person who entered into a diversion agreement under an ordinance cannot get another diversion agreement in their lifetime. That's the current rule. We're trying to preserve it, right? So not a policy change. By putting the phrase prior to July 1 in line 22, it might not have been as clear as it needed to be. Putting it at the end of line 23 and saying that you cannot enter into a diversion agreement if you have one for a violation of an ordinance that occurred prior to July 1 of 2025 will make sure that anybody who committed an ordinance violation before that date change and gets a diversion is not going to get another diversion. And the potential issue would have been somebody who's, say, convicted, or not convicted, charged in the window right before the change in law, May, June of 2025, and the diversion agreement doesn't happen until maybe after July 1st or even in August. What do you do with those people? So it was kind of a technical issue, but it might be substantive for a small group of people. So I mentioned it to the chair, and she's bringing it on kind of on our behalf.
Okay, what questions does anyone have about the amendment? Okay, I'll go ahead and move my amendment that Jason just mentioned and seconded by Representative Osman. Any other discussion about the amendment or explanation needed? Okay, I'll close on the amendment, and committee ask you to vote on this amendment in front of you for Senate Bill 71. All those in favor say aye. Opposed, no? Okay, we have amended Senate Bill 71. And now, what other discussion do we have on the bill? Thank you, Representative Barrett, for your discussion. Anything else on Senate Bill 71? Sorry, Representative Carmichael.
Thank you. I anticipate voting in favor of this amendment. I do have a reservation, and I at least want to make people aware of it, that we are taking away the power of cities to prosecute this crime. And I think the reason that we're doing this is we want to elevate it to the level of a felony. And cities can't prosecute felonies, they can only prosecute misdemeanors. But I fear we may look back at some point and question the wisdom of what we've done here. An example might be possession of marijuana. And possession of marijuana, simple possession, is a misdemeanor, so it's not totally analogous. But we have a situation right now in my town, and perhaps many of your towns, where city councils have done away with the possession of marijuana ordinance. And as a result, law enforcement officers cannot issue a notice to appear. Rather, they have to make an arrest, book the person, and then the district attorney or the county attorney has to charge under the state law. And as a result, there are people in my town who are smoking marijuana on their front porches because they know that absent exigent circumstances, law enforcement has other things to do. And I have some concern that in the long game, there may be instances where law enforcement, because of the press of other business, and I don't mean to denigrate sale of sex and trafficking, but I fear that there may be circumstances where if law enforcement could issue a notice to appear, that people would be prosecuted for this crime and at least get a conviction out of it or a diversion agreement. But when you elevate it to a felony level, then it requires complaint, information, preliminary hearings, trials, the involvement of the district attorney or the county attorney. And as a result, I think there may be people who, in the exercise of both law enforcement and prosecutorial discretion, who would have been prosecuted under a city ordinance, who may avoid prosecution. We'll see what the future brings, but that's my concern.
Committee, do we have any other comments? Or Representative Osman?
Thank you, Madam Chair. As to the previous representative, I agree with it. I thought about that for a little bit, but I do also agree that this is a good bill, and I'm happy to support it. I do have a question. If the revisor would be able to remind me, what happens when we do elevate something to a felony? Do the individual municipalities need to take an active role in rolling it off of their ordinances, or does it just become an inapplicable ordinance still on the books?
Madam Chair, Jason Thompson, Revisor's Office. So I don't know that there's anything, I mean, they're unenforceable, I suppose is the short answer. And I presume most cities will take affirmative action to remove them. But there's nothing in the bill that necessarily speaks to sort of unwinding it. And I think of, say, the Scrap Metal Act, right? We enacted a statute that said all those ordinances are hereby void. So that did it. Nothing else had to happen, but I'm assuming most cities went back and cleaned up their codes. So I'm assuming the same kind of situation here.
Okay, committee, any other question? Yes, Representative Carmichael.
Share what little wisdom I have on the topic raised by Representative Osman. I believe that the Kansas League of Municipalities has, and I don't know what they call it, but it's sort of a uniform set of ordinances, and they go through every year after we've done our work, and they recommend to their members cleanups of municipal ordinances, particularly criminal ordinances, to conform with things that we've done in the legislature. So my presumption is that most communities who utilize some of those services are going to follow their recommendations. Now, cities like Wichita, I would presume that the city attorney would, virtually immediately repeal the ordinance. But as Mr. Thompson says, if we pass this law the day it becomes effective, the city ordinances are no longer enforceable, as far as I know.
Thank you. Anything else? Okay, I will entertain a motion for Senate Bill 71. Representative Williams.
I move we pass Senate Bill 71 as amended favorably for passage.
We have a second. Representative Barrett seconds. Okay, committee, you have heard the motion to pass Senate Bill 71 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, we have passed Senate Bill 71 as amended. And Representative Carmichael would like his favorable vote recorded, please. Okay, committee, we're going to now move to House Bill 2349. The revisor just mentioned scrap metal, so let's just go ahead and do that. That is 2349.
Thank you, Madam Chair. I didn't mean to drive the discussion in that direction. Clearly, it's on my mind. As you mentioned, House Bill 2349 is the Scrap Metal Theft Reduction Act changes. This is the one that would authorize law enforcement to also enforce the act. Right now, it's only the Attorney General that can do that. It also establishes some criminal penalties for certain violations and would allow municipalities to have resolutions, counties would have resolutions or cities would have ordinances that are not in conflict with the act. They'd be allowed to enact those again.
Okay, thank you. Committee, I'm going to go ahead and ask if there's any amendments. I think I'm offering the amendment, but okay, yes. Okay, we do have an amendment on this bill, and thank you. I will let you know that I'm really pleased that we were able to come to an agreement about this bill and what's happened. And it took a lot of meetings and discussions, and lots of stakeholders were involved in this. I can't even tell, maybe 6 different entities and so on. So there were 2 parts to the initial bill. There was the one part that, as you see on page 1, line 25, that Kansas law enforcement officers are authorized to conduct investigations. And so there was that part of the bill. And then there was also another part of the bill that added some criminal penalties and not just civil to the Scrap Metal Act. And the issue is that if you all remember when it was brought to us, the bill, the problem was that there were things going on that were not being enforced. And so we needed enforcement from, right now, the AG's office has that duty to enforce. And so because of various reasons, what we ended up, and all parties have agreed to this, is that we struck everything adding anything criminal to it. We left that the same as the scrap metal bill was before, but we do give law enforcement officers the authority to conduct investigations, and that means they can go on the premises of scrap metal dealers now, and they can investigate, whereas before, they were not able to go onto the property. They had to wait for the Attorney General or a designee to go with them onto the property. So, this really does deal with maybe 1 or 2 or 3 counties in Kansas more than it does other counties, but this is a first step, and it was agreeable to law enforcement and others. So that is the amendment. I would be happy to answer any questions anybody has about that. Representative Osman.
Thank you, Madam Chair. Just a clarification. You had said all parties. As I look at it, I don't think there were any opponents to it. Are we talking about the neutral party, or is there another entity that we're discussing here?
Who was the neutral? Do you have it? Okay. Okay, so maybe we didn't have opponents, but, and if I remember, yes, we heard this bill on a Monday. And so it was a little bit, I think maybe we didn't even announce that we were going to have the bill hearing until maybe Thursday or Friday the week before. So I do feel like there were some people that felt like maybe they didn't have the opportunity to be heard yet that I have heard from. So I've heard from the lobbyists from the scrap metal dealers, Wichita Police Department, the AG, the DA from Sedgwick County, a couple others. So everyone kind of came together and they were fine with this. So, yeah.
Thank you very much for the clarification, and thank you for opening it up to a wide variety of people that couldn't make it to the hearing.
Any other questions for anybody about the motion, about the amendment? Okay, I'll move my amendment for amending House Bill 2349, and I would need a second for that. Representative Curtis seconds. Any other discussion? Okay, committee, you've heard the amendment for House Bill 2349. All those in favor say aye. Opposed, no. Okay, thank you so much for passing that amendment. And now we'll just open it up to the underlying bill. Are there any other questions about the bill in general or to the revisor or anyone else? Okay, seeing none, I'll entertain a motion. Representative Curtis.
Thank you, Madam Chair. I move that we pass out House Bill 2349 favorable for passage.
Hey, do we have a second? Representative Ward seconds. As amended, yes. Thank you so much. Yep. Okay, all right, you've heard the motion. Any other last minute discussion? Okay, would you like to close?
Close.
Okay, thank you. Okay, you've heard the motion to pass House Bill 2349 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, thank you so much. We have passed House Bill 2349.
Madam Chair, could I have my affirmative vote recorded in the minutes of this meeting, please?
Absolutely.
Thank you.
Representative Carmichael, affirmative vote. Okay, committee, I think we're going to go ahead and look at Senate Bill 53. It had to do with law libraries. And Jason, if you could remind us about this bill.
Thank you, Madam Chair. Senate Bill 53 had the two parts. First, to change the membership of the Board of Trustees of County Law Libraries in the counties that aren't Johnson, Sedgwick, and Douglas. That's the one that you'd pick two attorneys. The chief judge would pick two attorneys from the county to serve on the board. And then the other change was the funding change that in counties except for Johnson and Sedgwick, the Board of Trustees can authorize the chief judge to expend certain funds that are brought in for libraries, but for other district court purposes. This would add a second pool of fees that they could do that with, and those fees are collected by the clerk of the district court.
Okay, thank you. Committee, any discussion or amendments on this bill? Okay, Representative Osmond.
Thank you, Madam Chair, actually. Appreciate it. This session feels like a fever dream, and I don't even know if I've asked this question in the original hearing, but I'm going to ask it now because, again, it refreshed in my memory. I'm in support of the bill. The bill is fine, but I guess the underlying question is, why is this bill necessary in the first place? Like, why do we need a state statute to enact for county law libraries rather than have the county law libraries enact their own rules and regulations?
Lovely
Did
question.
I ask that question? I
Yeah.
think I did. I think I did. I'm still confused on that. I'm fine. The
He
bill
answered
is
it.
fine. I don't understand why we're doing this.
Representative Carmichael.
Thank you, Madam Chair. I could be wrong here, but I think the reason is the county law library board, et cetera, they don't have the power to enact laws, statutes, force lawyers to do anything unless we give them the power. And that's why we've got to have it authorized in statute and required. Otherwise, scofflaws like me would have never paid our library assessment fees and we wouldn't have a library.
Lawyers are just, yeah, can't get them to do anything, right? Okay, so I think, does that answer your question?
Thank you.
Okay. Okay, any amendments or discussion on this one? Okay, then do we have a motion? Yes, Representative Carmichael.
By the way, did we get an amendment on this or do we?
No,
need one?
we've decided we're not going to do an amendment on this one.
I'm not going to make the motion then, never mind.
Would you like to amend it?
Rather than do that, I'll simply move that we report out Senate Bill number 53 favorably for passage.
Okay, thank you. You've heard the motion. Do we have a second? Representative Williams seconds. Okay, any other discussion on this one? All right, would you like to close, Representative Carmichael?
Madam Chair, this is very fine and vital legislation to the future of the state of Kansas, and I urge its adoption. I close.
Okay, committee, you've heard the motion to pass Senate Bill 53 favorably for passage. All those in favor say aye. Opposed, no? Okay, we passed it. Okay, committee, now we're going to go ahead and work House Bill 2131. Okay, Jason, could you give us a reminder about House Bill 2131?
Thank you, Madam Chair. This one was a little older. You heard it, wow, was that January? Bill brief, wow. All right, this is the one that requires prosecutors to disclose their intent to introduce testimony from a jailhouse witness and to also forward related information about that witness to the Kansas Bureau of Investigation, who will keep a database of information that prosecutors will be required to look at. That's probably enough from me, unless you need something else specifically.
Okay, I'll open that up for discussion. Does anyone have any discussion? Representative Lewis.
I brought the bill. I support the bill. I can explain that support, but I think maybe first I'll offer an amendment.
Okay.
2130.
We will get that passed out, so hold on just a minute. As I think it's good to be looking at it when you explain it, so thank you. Okay, Representative, if you could go ahead and explain your amendment to us, please.
Right. The amendment concerns the definition of a jailhouse witness on the second page near the bottom. It's largely, if not exclusively, an amendment that I think helps to clarify more than change the substance. So I'll just start with the jailhouse witness means a person who provided testimony, and then the original bill said or is intended to provide testimony. And I'm just changing that to or whom the prosecutor at some point intended to call a witness. So basically what this deals with is a circumstance where the prosecutor is approached by the jailhouse witness, decides to use that jailhouse witness as a witness, and for reasons having nothing really to do with the jailhouse witness, he doesn't need to use him. For instance, it could very well be that when the defendant, criminal defendant, learns that the jailhouse witness is planning to testify, he will plead guilty, and therefore there's never a need for him to actually be a witness. So that takes into account that circumstance. Another small amendment, commas sometimes can be important. Line 41, right before the and there. The reason for that is talking with Representative Barrett and others, it was determined that this is definitely a conjunctive condition to be defined as a witness. That is to say, you have to either be a witness or intended to be a witness, and you have to receive a benefit or possibly receive a benefit. And that comma, I think, raised some ambiguity as to whether this might be disjunctive. So we took that out just to make doubly certain of that. And then the final change is deleting or may in the future receive a benefit to or possible benefit. Once again, so the way that comes up is the prosecutor enters into it's almost always a written agreement with the witness and says, you know, basically, we appreciate your being willing to testify against Mr. X. You know, it's very important that you always tell the truth, and we will agree that after you have testified and after we've assessed your truthfulness and other conditions, we will, in our own discretion, decide whether or not to ask the court to give you a benefit sentencing. So that's why the notion of a possible benefit is necessary in the definition. So with that, I move my amendment.
Not on the microphone. I'll go ahead and get a second and we'll have discussion. Representative Williams seconds. Okay, now questions and discussion. Representative Osmond.
Thank you, Madam Chair. Okay, so it's been about 5 weeks now, but as I recall, there were a number of opponents to the bill, and they had a number of objections to it. One of them, as I recall, was that one of the problems is if you have a proposed, if somebody is intending to, they could just write in a letter to the DA saying, hey, I got information, I'd like to be a witness, and now suddenly they need to go on the massive database, they need to be shared from DA to DA. So this amendment takes care of that situation.
Right. So I think the bill as originally written actually took care of that condition. That is to say, it's not a situation either under the original bill or as amended. And as I said, my amendment is really clarifying that just because somebody came and said, hey, I have some information, that it would go into the database. Because your observation's right. The definition of this requires more.
All right, thank you.
Okay, other questions? Representative Barrett and then Bohai.
Thank you, Madam Chair, and I do want to thank the Representative Lewis for discussing this with me and going back and forth. One question I did have after talking further with another organization is, so I guess 2 questions. First, so, or whom the prosecutor at some point intended to call as a witness. So if this case, like many cases, ends up going to, they just plea out, but before they pled out, while the prosecutor was building their case, if they did intend to call someone as a witness, but again, it ended in a plea, would that individual still need to be put into the database?
Yeah. Yes, as I understand it, because he would be a jailhouse witness as defined.
Okay. And then my second question is when you reference or a possible benefit, I mean, I guess I get stuck on that. How do you define what that when it's a possible benefit? Is it just because of a prosecutor had to offer that still first, or can you further clarify that?
Sure. Either he has been offered a benefit or a possible benefit. And as I explained, the possible benefit circumstances where, as I said, most of the agreements that you enter are basically possible benefits. There's no guarantee of benefit because you're testifying. That will depend, number one, on the prosecutor's assessment of your testimony and ultimately on what a court will decide if and when the prosecutor decides to ask for benefit to be conferred. That's why that's necessary.
Great, thank you. So just if I have one more, just to clarify, first, the prosecutor has to have intended that this person was going to be a witness, so they already have the person on the list to testify. And then second, they have had to have offered a benefit.
Right.
Okay, thank you.
Representative Bohai. Already what? Jay. Okay, Representative Carmichael.
I don't mean to slow you down. Okay. I hope Aaron Breitenbach from the Deputy District Attorney in Sedgwick County is listening, because he and I discussed this legislation last night, recounted some stories of old. I've got some possible concern about this amendment, and not from the standpoint of the defendant's rights or the list, but the position it puts the prosecutor. And I'm going to probably go ahead and vote for the amendment, but I at least want to make my concerns known so that when it gets to the Senate, hopefully law enforcement and prosecutors can really chime in and make sure this is what we want to do. But when I see the phrase, "or whom the prosecutor at some point intended to call as a witness," I think that's too broad in this context. You know, as a prosecutor, I might intend to call somebody as a witness. I might never make an offer of a plea bargain or an inducement to testify or anything else. I just know that Mark Schreiber's in the cell with this defendant over here. And, you know, I think I'm probably going to call Mark because I bet that guy's ranting in there every night about his intent to commit the murder. And then I realize that's not the case. I never use Mark. But this phrase at some point intended to call, I think is probably too broad. I think perhaps the better language might be whom the prosecutor endorsed as a witness. But I'm not familiar enough with criminal procedure today in Kansas to write that amendment or to change it. But I know the procedure typically is that if you have the so-called jailhouse witness, just like any other witness, you have to endorse those witnesses and identify them to the defendant as someone that you intend to call or that you may call. And I'll go ahead and vote for this as it is, but I'm sure that people like Mr. Breitenbach, who practice in this area all the time, ought to take a careful look at it. So that's my comment.
Okay, committee, any other questions, or would you like to respond, Representative Lewis?
Yeah, I'll just say that I appreciate the concerns you raise. I'm more than willing to talk, but I still want to move my amendment.
Okay. Yeah.
And by the way, if they are listening, maybe they'll get in touch with one of us before this bill hits the floor. And maybe we can agree on some modification there, as I hate to rely upon the Senate.
Representative Barrett.
Just for procedure, if I want to discuss a possible amendment that may also work at this, since we're currently discussing an amendment, how should I wait till after, or?
Hang on just 1 second. Okay, so Representative Barrett, so just checking with the revisor and my leadership over here, you are able to make, if you feel like you would like to make a substitute motion with your amendment, that is permissible in the committee. You can do that. It's kind of, there's no right or wrong necessarily on which amendment sort of preempts the other one. We could finish this one, or you could do a substitute motion. We could hear yours. If it failed, we'd be back on this one. It's just, it's actually it's how people want to handle it who are offering the amendment. It's their choice.
Then I would like to make the substitute amendment to this.
So you want to go ahead and make a motion for a substitute amendment?
Yes, I'll make a motion for a substitute amendment.
Okay, and do we have a second on that? Representative Bohai seconds that substitute amendment motion. Thank you. Okay, I think everyone has it now. Representative Barrett, if you'd like to explain your amendment. Okay, yep, Representative Barrett.
Thank you, Madam Chair. And I didn't know if I was going to bring this amendment or not, and as we further discuss Representative Lewis's amendment, I just wanted to at least bring this up so we can discuss it. The KCDAA had worked with myself and the revisor, and they had felt that this language was a little more tight. This maintains the database, which I think was important to everyone, but it does strike out or is intended to provide testimony, and it also strikes out has requested on line 41, then in line 42, or may in the future receive a benefit. I think the prosecutors just felt this kind of made the language better, a little more clear. Again, I can see both sides of this. I actually kind of discussed this with Representative Lewis, and so I understand there may be dissenting opinions, and I do see that there's both sides to it, but I think this would provide some clarification.
Okay, committee, what questions do you have for Representative Barrett on a substitute motion? Representative Lewis, questions or comments? Representative Lewis.
Right, so I think I'll just sort of briefly repeat what I said before. The reason I object to the deletion of or is intended to provide testimony, and my amendment said the same thing, but I think more clearly, is because of the circumstance where you entered into agreement with the witness, and the witness is perfectly willing to testify, and his willingness is cause for the prosecution to benefit from not having to go to trial because of a plea. And then the jailhouse witness rule wouldn't apply, even though that jailhouse witness is getting a benefit likely down below, where the prosecutor will go to the court and say, well, his willingness to testify, provided the benefit to us, if you would, of a plea. So, and then as to the next strikeout, he goes on and says, and who has requested. I think that's important because that's showing that the witness has sought a benefit, and that's relevant to his credibility, I think, and would be something that the defense would be rightfully entitled to. And then the strikeout or may in the future receive. Once again, I explained that that's important because the nature of these agreements is that they're conditioned on a number of things that that will be determined only actually when the judge ultimately decides on whether there should be a benefit, but there's still an agreement to possibly give the benefit or to the witness. So.
Okay, committee, what other comments or questions do you have about the amendment? Representative Schreiber? We're on Representative Barrett's substitute motion. Do you have a question about that one? Okay.
Thank you. Sorry. Is it important that the witness has requested or just that they've been offered a benefit?
That is the question. That's one of the questions. Representative Barrett.
Are both needed to make this palatable or what?
Yeah. And thank you, Representative Schreiber. And I can definitely see Representative Lewis's point. I would say that, though, what's important is to me is if it's offered. So they were offered this benefit. So now that plus they're going to be used at trial. So to me, that just shows that they're going to be used in the trial and they were offered a benefit, whether it was requested or not. It's important if it was offered.
Representative Schreiber.
So, so it could be where the prosecutor went and just offered the benefit without the witness coming forward. They just,
No, because it does require that that they're intending to use them as a witness, and then that benefit was offered to them. So I guess,
yeah, understood that part, but it wasn't necessary for the witness to come and request that of the prosecutor, correct?
I believe that's correct, yes.
Thank you.
Representative Carmichael.
Thank you. Thank you, Madam Chair. For the third time, I fear I must agree with the distinguished barrister from Finney County. If only it could be so every day, Representative. I think my friend Representative Barrett's amendment goes too far. I think that Representative Lewis is correct in what he has decided. While I still might have concern about the phrase that he used of at some point intended, I think that's something we can fix pretty easy, but this is a very different thing that we're seeing here from Representative Barrett's amendment, at least in my view, and I'm not going to endeavor to repeat the same things that Representative Lewis said, but I do believe that the fourth-time distinguished barrister from Finney County has the better language here. Thank you.
Representative Bohai, and then we'll get back to Representative Lewis.
Thank you, Madam Chair. I agree with the barristers that are agreeing with each other because in reading what was struck versus in reading the other one, are we allowed to talk about the other one? Okay.
As a chair, I'll say yes, because you actually have these two things in front of you right now. You're comparing them and deciding which one you prefer. And so, yes, I think that's very appropriate.
Okay, so because the First Amendment that was proposed has the word "and" in there still, meaning it still has to have provides testimony, or was going to provide testimony, which covers it didn't need it because it got pled out type of situation. And then it has the and who has requested, and then or was offered a benefit or possible, but like, because it still has those two components. They provided the testimony and they received a benefit or were going to receive a benefit. I believe I can appreciate what the First Amendment was doing. Thank you.
Representative Lewis, did you want to speak? I mean, you kind of,
I have no more discussion.
Okay. Any other discussion on Representative Barrett's substitute motion to amend? Okay, Representative Barrett, you may close.
Thank you, Madam Chair. And like I said, I just wanted to bring up another option that was brought to us by our prosecutors. But with that, Madam Chair, I do close.
Okay, and committee, just to remind you, if you vote yes, this will be the amendment. If you vote no, we'll go back to the other amendment after. Okay, so all those in favor of Representative Barrett's amendment, a motion to amend, say aye. Opposed, no? I believe the noes have it. So we are back on the amendment that Representative Lewis offered. What other discussion do we have on that one? Okay, seeing none, Representative Lewis, you may close.
I close.
Okay, committee, we have that motion in front of us from Representative Lewis. All those in favor say aye. Opposed, no? Okay, so we have amended House Bill 2131 by Representative Lewis's amendment, and now we are on the bill. Okay, just a second. Okay, Representative Lewis on the bill.
Thank you, Madam Chair. So I'll try and be brief. I think this bill is beneficial to the entire justice system. I think both prosecutors and defendants or defense lawyers will benefit from it. The first part of the bill simply sets forth in some detail the obligations of disclosure that a prosecutor has when he's using a jailhouse witness. And it's true, as we learned in the hearing, that under Supreme Court precedent going back many years, prosecutors are obligated to disclose to defendants all exculpatory evidence and also impeachment evidence. And in some way, in a real way, this sort of just duplicates that obligation. I would say, however, that because the Brady case and the Giglio case are judicial decisions, and there are a lot of decisions that have come out since then, in this case and that case. As a prosecutor, you oftentimes are not clear on what your duties might be under Brady and Giglio. And so, although this doesn't purport, and nor could it define constitutional obligations, I think it would give some comfort to prosecutors to know that the legislators have stepped in and said these are what we think are obligations under this scenario. And I think it would be more difficult if those obligations were fulfilled for the defendant to later claim that they hadn't been given all of the information they deserve. On the other side, I think that defendants will benefit because, once again, they will be getting the information that's required. The second thing I would say is that as a prosecutor, when somebody like this comes to you, your concern is at least twofold. One is this person credible? Because that's important, because you want to do justice and you don't want to convict somebody that's not guilty of that's charged. And you also are concerned about the question of, even if the defendant is guilty, is this witness going to be credible enough to convince a jury beyond a reasonable doubt? You don't want to bring a case that you are going to waste resources trying, only to find out that the witness is so incredible that you end up losing the case, and then it's all for naught. The database, I think in that regard, is very helpful to the prosecutor, because once again, if you're a prosecutor, you want to know everything you can about this witness before you make decisions about whether to use him. And the database will give you easier access to that kind of information. Currently, if you're looking at that, and you'll probably ask around in your office for other prosecutors, obviously, that have used this witness, and you may have a friend or two in other prosecution offices, and you may call them up. But this is a database that's centralized. It's easy. You can go to it, and you can learn about any use or of this witness by anyone else in the state. And I think that's very helpful to the prosecutors in making a decision as to whether to move forward with this. And the other thing is, the last thing a prosecutor wants to know is to learn something about this witness later. And so I think this database in that respect is very helpful to prosecutors. And from the defense perspective, again, it gives some greater assurance that they're going to get all of the relevant information about the witness that they deserve in order to cross-examine the witness and defend their client. There were a couple of objections that I wanted to briefly address. We heard that the database would not be secure, and I think that the FBI, both at the hearing and later in my discussions, assured me that there's sensitive data in their database now, and this isn't qualitatively different. I mean, if our concern, and we're going to say that anytime there's a risk of a data breach, we're not going to keep databases, I think we should throw away our cell phones, because there's always a risk of that. The other objection I heard was that it would be burdensome on county attorneys, especially in less populated counties, to fulfill their obligation to input the database. I guess I really don't think that this is going to come up that often, that it's going to be that difficult for them to comply. I also heard the objection that we would be putting prosecutions at risk of being overturned on post-conviction motions where, for instance, you have a situation where a prosecutor in another part of the state didn't do his job to input data into the database. And that's certainly a possibility. But what I would suggest to you is that would happen once. As soon as one prosecutor in one county didn't do his job or her job, and that infected the prosecution, successful prosecution perhaps in another county, I think that the prosecutors as a whole would band together and the opprobrium against that prosecutor, we make sure it wouldn't happen again. They also said that, well, this is a problem with bad characters. It's a bad character prosecutor problem, and if the prosecutor is a bad guy or girl, you know, this isn't going to matter. I disagree with that too. Once again, under the current system, a prosecutor, bad prosecutor, decides to use a snitch, and let's say, I think this was the case in the Coons case, but I could be mistaken, but hypothetically, he talks to another prosecutor and learns some bad stuff about the snitch and decides not to turn it over. Now that's a Brady violation, right? But without a database, there's less likelihood that's going to be caught. With the database, that bad prosecutor is going to be taking a much greater risk of being caught than he would otherwise. So that I think this does something to discipline and take care of the bad prosecutor character problem. With that, I will open for questions, further discussion.
Would you like to make a motion on this bill?
I have not, and I will.
Okay.
Yeah, I move that we pass this favorably.
Okay, and Representative Ward as amended. As amended.
As amended.
Representative Ward, you had a question. Okay, what, do we have a second? Representative Williams seconds, and we do have several questions, so we're going to go ahead and do that. Representative Ward, do you have a question?
Thank you, Madam Chair. I was just looking through most of the testimony and wondered, there's a $250,000 price tag on this, I think, or around that, maybe 180 plus whatever it takes to maintain. Does anyone recall how often this happens? Like, I know those 6 district attorneys testified that day, but did anyone remember how often they said this actually happens?
Representative Bohai.
Are you speaking to the fiscal note?
Mm-hmm.
So it's my understanding that sometimes the fiscal note is a little inflated, and I don't know if this is going to take a total full-time employee to manage this database.
So I will say, whenever a bill is amended, the chair may ask for a revised fiscal note. Since our bill was amended, we are able to ask for a revised fiscal note, and we can do that. I can't do it, of course, before we vote on it today, but before we can ask for a revised fiscal note. And I will say, I have heard from a DA in a very populated county that they maybe have 2 or 3 a year. This with the jailhouse witness, if that is helpful to you. Representative Lewis.
The way I understood the fiscal note, may be wrong, was that the upfront costs will be much more. The KBI will have some upfront costs in setting this up, but once it's set up, it really shouldn't take much to maintain it.
Okay. All right. Other Representative Vaughn.
Thank you, Madam Chair. For the maker of the motion, I would be curious in their thoughts on this. I think the concern in regards to the database was the threat of the breach, but more that threat of the breach or potential breach would have a chilling effect on potential witnesses, which was maybe the one thing you didn't necessarily address. And that's one thing I have been thinking about. I mean, I don't know in practical terms if that really would enter into a potential jailhouse witness's thought process when they determine whether or not it's something they would want to do, or, you know, the benefits that you mentioned, if those benefits overall just outweigh any potential negative chilling effect it might have. But I guess that's one of the things I've been thinking about the database specifically, and I'd be curious in your thoughts.
Representative Lewis.
Yes, thank you. Thank you for the question. So if a jailhouse witness comes forward and wants to testify, at least, you know, suggests that he would be a good witness, and he certainly, if he testifies, that's going to be public knowledge. So I mean, he's going to have to consider that risk under the current setup, regardless. I don't see that the database really increases the risk to him because he's under the definition of our witness jails. It's not just somebody that comes and gives information. It's somebody that actually is committed to going public with that testimony, which obviously raises the risk. I don't think that the database increases it much greater.
Those are good points. Thank you. Thank you, Madam Chair.
Okay, any other discussion or questions before we vote on the motion? Representative Osman.
Thank you, Madam Chair. So I know this bill is very congruent to the one that we did last year, 2293, that passed 117 to 4. I voted in favor of it. I'm generally in support of this bill as well. The amendment that we made did make it, I think, even stronger. That said, you know, the opponents did have some good good comments and good rationale, and I know that you addressed them as well. There was the cybersecurity risk, and hopefully we can find a way. There's a way in implementation that we can mitigate that risk, whether that's through additional robust cybersecurity, additional policies and procedures, or maybe there's even an amendment that could take place on the Senate side that would help to mitigate that risk or address that concern. But that said, I think the underlying bill is sound, and I'm in support of it.
Okay, thank you. Any other, yeah, just one second. Any other questions? Okay, seeing none, Representative Lewis, you may answer, and then if you would close, please. Thank you.
Just briefly, you may recall Director Mativi talked to that, and he mentioned, I believe, that his predecessor rightfully was concerned about putting the current database, which, as I said, I think contains equally important, you know, confidential information that they don't want out in all the world. He didn't want to put that on the cloud, for instance. So apparently, everything is in-house in terms of the storage. And I subsequently spoke to another person at the FBI, and he's, you know, there's no assurance, obviously, but they feel very confident that they're doing everything they can to secure that and the information they already have, and that they can secure this information. So I close.
Okay, thank you. Committee, you have heard the motion to pass House Bill 2131 favorably for passage as amended. All those in favor say aye.
Aye.
Opposed, no. Okay, the ayes do have it, and we have passed House Bill 2131 favorably for passage. We're going to do one more.
Madam Chair, would you
Yes.
please record my affirmative vote?
Yes, okay.
Thank you.
And that's it? Okay. Okay, committee, we're going to do one more. We're going to do Senate Bill 84, which was the bill that we just heard, or sorry, we heard last week about gift cards. And then the others that we had on possible for today, we'll hold off on the other two. But so gift cards is Senate Bill 84. And I do have an amendment for Senate Bill 84. Okay, first we'll have Jason remind us what this bill is about, and then I'll tell you about the amendment. Yes.
Thank you, Madam Chair. Yeah, your brief reminder, this is the bill that amends the crime of criminal use of a financial card to include gift cards specifically, and to add a couple of specific violations related to acquiring or retaining possession of gift cards without authority, and also altering or tampering with gift cards.
Okay, thank you, Jason. And the amendment just changes the effective date from the statute book to the Kansas Registry. So a little tweak. Representative Carmichael.
Thank you, Madam Chair. I stand firmly opposed to this amendment. It's always been a long tenet in Kansas criminal law that they become effective on July 1, and practitioners presume that to always be the case, that July 1 is the effective date. Notwithstanding that, oh, this is Senate bill. Never mind.
Okay. Okay. All right. Any other discussion on the amendment? I'll move my amendment. I'm sorry. Yeah, I don't have one yet. I'll move my amendment, and I do need a second. Representative Osmond seconds. And any other discussion on the amendment? Okay, all those in favor of the amendment to Senate Bill 84, say aye. Opposed, no? Okay, thank you. Now, on the bill, what discussion do we have otherwise on the bill? Any other questions or comments? Okay, Representative Williams.
Thank you, Madam Chair. I move that we pass Senate Bill 84 as amended favorably for passage.
Do we have a second? Representative Barrett is who I saw first. Okay, seconded by Representative Barrett. Any other discussion on that? Okay, committee, then you've heard the motion to pass Senate Bill 84 favorably for passage as amended. All those in favor say aye.
Aye.
Opposed, no? Okay, we have passed Senate Bill 84. Okay.
Madam Chair, would you please
and
record my
Representative
affirmative
Carmichael
vote?
would like his pro vote recorded. Okay, committee, so thank you for your really good work today. I so appreciate it. Next week is going to be a full week, so I'm thinking we may go past 5. We have multiple bills each day that we need here. We got 2 new bills assigned to this committee, one today and one yesterday, so we'll see if we can get to those 2. I'm kind of trying to save those last 2 days, March 17th and 18th, just for cleanup if we need that. But, and of course, I will try to not meet next Friday, but I don't know about that yet. So that's where we're at, and thank you so much, and we're adjourned.